For the next three weeks, we're going to move on to a new unit, and we're going to move on to a unit of discrimination. All right. So we'll talk about discrimination, and we're going to focus on discrimination for several weeks. And I'd say for several weeks, quite a few class periods, because it's an important part of employment law. And that's what we're here: employment law, and what's the rest of our title? This class is employment law and, anybody know? Isn't it employment law and discrimination? Maybe not. I don't know. It's just a class, right, that you had to take in order to graduate. I know how it goes. All right. Well, regardless, discrimination really is an important part of employment law. And I'd say, at least in my former practice, I probably engaged in 60% of what I did was discrimination. Not a day goes by that we're not working in some way or another in our particular business now in a discrimination claim. I mean, when you have 9,000 plus employees, you're going to get discrimination claims, and that's what we have scattered throughout the country. And so we get discrimination, and that's where we're going to focus on for the next few weeks. And when we talk about discrimination, probably for the next 2 or 3 units, whatever it turns out to be, we're going to talk about an introduction kind of to these discrimination claims, and then we're going to focus on race discrimination. Okay? Then after that, we'll look at sexual discrimination, and then some others: age, disability, religion. There will be several that we talk about. So back on, because this information is more covered in your text than what we've looked at in the past, probably get more questions as opposed to what we've done in the past where it was spoon feeding. Over the last few units or few weeks in Unit 2, we did a lot of what I call spoon feeding. I don't mean that negative in any way, but here we're going to get back into, okay, you tell me what some of this stuff means, and we'll fill in the gap. So as we talk about discrimination, let me just give you a little bit of background. Most of the discrimination laws come under what is called Title VII. Okay? Most of them come under what is called Title VII. And Title VII is part of the Civil Rights Act of 1964. It is part of the Civil Rights Act of 1964. And it really is the foundation of some of our modern equal employment opportunity law. The laws are designed, certain laws are designed to provide equal employment opportunity. And if you say to lawyers, name one law that's more important to equal employment opportunity than any other law, they'll tell you Title VII, or they'll tell you part of the section of part of the 1964 Civil Rights Act. Okay? Now, throughout, you may have read in your text or in your reading, you may have read information about different types of act: the Race Relations Act, section 1981, 1983. 1866. There are all kinds of laws out there addressing discrimination, whether it's in sex, whether it's in race, regardless of the nature of it. But really, most of it all, and a lot of those overlap, but most of it that we're going to be dealing with in here is going to be what we refer to as Title VII, okay, which focuses on the 1964 Act. Now, that act became effective in 65. 64 Act becomes effective in 65, but since 65, it's been amended 2 or 3 times. All right? You have an amendment in 1968. You have an amendment in 1972. You have an amendment in 1991. And we'll talk about what some of those amendments did. Really, the purpose of it, when you got into the reason it had to be amended is like all of our other laws. People want something, then they barter back and forth, and finally they come to a conclusion, and we'll talk about what those changes were. But basically, here's what Title VII does with regard to employment law. I mean, it does with regard to employment law. It prohibits discrimination and or retaliation. Okay, so it prohibits discrimination and or retaliation in terms of the conditions of employment on the basis of race, color, religion, sex, or origin. Okay, I'll give that again. Title VII basically prohibits discrimination and or retaliation. Talk about what retaliation is a bit too. But it prohibits discrimination and or retaliation in terms of conditions of employment with regard to race, color, religion, sex, or origin. Okay? Now, and we'll get more into this next week, but just by make sure we clarify now, when they prohibit discrimination based on sex, what is it prohibiting? Gender, okay? Not preference. And we'll talk about that in more detail next week when we talk about, or whenever we get to it, when we talk about sexual discrimination, okay? Now, Title VII was important because it created what is known as the Equal Employment Opportunity Commission. Okay? It created what is known as the Equal Employment Opportunity Commission. And basically, this commission is made up of 5 members, if you will. Now, let me tell you right off the start, these 5 members of this commission don't handle all the discrimination cases, okay? You just have a board that oversees the running of the commission itself. Okay? There are a lot of investigators and different people like that that work with the commission. But the board itself is a 5-person commission. Now, originally, before this law could pass in '64, 2 things had to happen. Number one, they had to defer to state and local agencies. Commission couldn't make all the decisions themselves. They had to defer to state and local agencies. For instance, Missouri now has what is called a Missouri Commission on Human Rights. Okay, that's a state agency. So before the '64 law could become effect, there had to be a provision for a deferral to state and local agencies. Didn't want to give the federal agency too much power. The second thing is the EEOC could have no prosecutorial role. Okay? And what do we mean by when we say the EEOC could have no prosecutorial role? They can't bring the suits. All right? Now, keep in mind this is in '64. All right? And that was a stumbling block, and in order for part of '64, the Title VII to get passed, they had to get rid of those 2 things. They had to make sure that deferral was left to state agencies. They had to make sure that the EEOC didn't have a prosecutorial role. All right? Now, in 1972, Title VII was amended so that the EEOC, or so that there could be a direct civil suit. Not the EEOC yet, but a direct civil suit. So that if somebody was discriminated against, they could file a lawsuit and seek civil relief. Okay. 1991, that change came about, gave right to jury trials for individuals. It also started imposing caps on statutory damages. What do we mean by that? Just to see if we need to go further in that. When we talk about caps on statutory damages.
A maximum amount of money you can get.
A limit on how much you can sue for?
Right, yeah. How much you can sue for, all right? So it doesn't matter if my damages are $5 million or whatever, there's a cap of what I can get. Really that cap, when you sue for, and we may have talked about this in terms of general, but let's kind of back up by way of review. When you sue, all right, for say a discrimination lawsuit, what kind of damages might you get? Let's say you've been, let's talk about race. We'll talk about race either later tonight, next week, sometime. When we talk about, let's say somebody has been discriminated on the basis of race and they've been terminated, all right? What kind of damages might they get as a result? Have they been damaged if they've been terminated on the basis
Lost wages.
Pat?
Lost wages.
Okay, lost wages, All right, so they can sue for lost wages. That's part of their damages. What else could they sue for? And we've not talked about it. Anybody? So we're suffering. Okay. Now, generally in a termination, what kind of suffering, Tom?
Emotional suffering.
Emotional suffering. Yeah. Generally in a termination, you don't have pain and suffering in the sense of you get run over by an automobile, you got real pain. Okay. In these employment discrimination, you generally are not going to have that pain, but you may have emotional suffering, emotional distress. All right? And we'll talk about those damages as we go along and how they come into play. But you could sue for them. The law has started putting caps on those so that you can't get more than, say, $300,000 for emotional damages. All right? Or whatever that figure may be. Okay? Now, the EEOC also received enforcement authority. Okay? They have the authority to enforce Title VII. They also have the authority to enforce other laws, such as the Americans with Disabilities Act, which we'll talk about in more detail later, the Equal Pay Act, which we'll talk about when we talk about sexual discrimination, and the Age Act, or the Age Discrimination in Employment. Okay, so age, equal pay, and the Americans with Disabilities, those three. I may have said age twice. Those are the three. Okay, let me give you a little bit of breakdown of how this works, and this is where it gets a little bit, I don't want to say confusing, but it's not the most exciting stuff, but it's important, and you'll have to know this if you're out there practicing in human resources. You're going to come across it, and it's going to be important for you to know so that you can either advise counsel or work with your counsel when you get one of these lawsuits or when you get one of these charges. All right, let's first break it down into federal or public sector discrimination versus private. And I'm talking on the federal level. When we talk about public sector, I'm really talking about the federal sector. All right. So let's take the U.S. Post Office, federal employer. All right. If there is discrimination on the federal sector, the employee must go to what we call an EEO counselor within 45 days. So let's say Tom is working at the U.S. Post Office. He has a female supervisor that hates males, and she makes comments to Tom about how she hates males, and he goes and files a complaint, believes he has a discrimination claim. If Tom's going to do that, he has to file this complaint or go to an EEO counselor within how many days? 45 days. All right. At that point, he may be given a right to file what is called a formal complaint. Okay. He's given a right to file a formal complaint. And the complaint, by the way, is filed with a federal agency. Be filed with the Postal Service or whatever the federal agency is, not the EEOC. And then he can appeal that right. And may eventually get to sue. All right? That's really what I want you to know on the federal sector. Now, we're going to talk about federal law in general, and I'm talking now about private sector mostly. Federal versus state law. Okay? So, for instance, and when we talk about federal law, let's make sure we understand there is a federal law which prohibits discrimination, and that law would be what? Anybody?
Title VII.
Title VII. All right? Title VII is a federal law that prohibits discrimination. You also have state laws that prohibit discrimination. For instance, and we'll just take Missouri. Missouri has Chapter 213 of the Missouri Revised Statutes prohibits discrimination on a state basis. So that there is a state law that makes it illegal to discriminate on the basis of race, sex, okay, those types of color, origin, religion, those types of things. Yeah, I mean,
What was it called again?
it's just the Missouri Commission, or the Missouri Human Rights Act,
Oh.
okay? It's chapter 213 of the, I'm not going to worry whether you know that it's chapter 213. I just want you to understand that there's a difference between a federal law and a state law. Most states have their own law that prohibits discrimination, but certainly there is a federal law, and we've been told that it's Title VII, okay? Now, here's the reason that it's kind of important to get down into that and understand that. And we touched base briefly on very early on when we talked about in our introduction to this class, but get more detail into it now. In a federal violation, you have to make a complaint within 300 days. All right? You have to make a complaint within 300 days. 300 days of what?
The incident?
Of the incident, sure. Okay? And the way you make that complaint is by filing what is called a charge of discrimination. With the EEOC. You don't file a lawsuit yet. You file a charge of discrimination. Okay? And you can file that with the EEOC because it's a federal complaint. All right? Violation of federal law. The difference is in most states, you file a charge of discrimination with the state agency. Missouri, for instance, gives you 180 days to file a complaint. Now, how many employees, just by side note here, maybe more than a side note, how many employees for Title VII? Have we talked about that? 15? All right. And that 15 is based on our 20 or more calendar weeks in the preceding year. Okay? We talked about another law previously, the Fair Labor Standards Act, some other laws. Okay? Missouri has a provision and applies to any employers with 6 or more. Okay. So if I work for, let's take it Kraft, okay? Do I have a complaint, and I feel like I've been discriminated against, do I have a complaint under the Missouri Commission on, or can I file a charge of discrimination with the Missouri Commission on Human Rights? Yeah, because they're going to have 6 or more employees. Can I also file with the federal, under the federal law? Sure, okay, because they're going to have more than 15, all right? Now, if I've got an employer that only has 7 employees, let's go back to the tire company. How many does the tire company have?
Well, right now we have 10 full-time now. So
Okay, but I mean, on a regular basis, you say 10 full-time.
yeah.
Is that pretty consistent? Okay, all right. If you work for Whitney's Tire Company, all right, and can you file a claim under the Missouri Commission on Human Rights? Knowing that they've got 10 full-time employees on a regular basis. Yeah. Can you file a claim under federal law? No. Why? Because they don't have 15. I mean, you could file it, but it's not going to go anywhere. Okay? So, difference, 300 days mainly for the federal, 180 days to file your complaint with state, at least with Missouri. Amanda?
I was gonna ask, is that just Missouri?
No, most states are that same way. but some vary. Most states are probably 180 days. Now, I promise I won't give you this particular question on the test, but let me make it a little more complicated. If you don't file, you can file your charge of discrimination with the Missouri Commission on Human Rights, either your federal charge or your state charge with the Missouri Commission on Human Rights. You with me? Okay? I don't have to file a federal charge with the EEOC if I file a charge with the Missouri Commission on Human Rights and say I want it filed both places. And the reason for that is, just give you a little background, the reason for that is there is what we call a work sharing agreement between most state agencies and the federal government, or the federal EEOC. So that basically I can file a charge of discrimination with the state agency, and I can say I want it duly filed, so that I file it with, they'll investigate it or switch it over to the EEOC. They'll look at it, they'll decide what they want to do. But I can file that charge with the Missouri Commission on Human Rights and say I also want this filed with the EEOC. That one piece of paper will take care of what I need to do, all right? Here's the deal. Even though Missouri has 180 days, and this is the one I would promise not to test you on, but I think it's important for HR purposes later on. Even if Missouri has the law that says 180 days, if you file your complaint with Missouri within that 300 days, you've still preserved your EEOC charge, okay? Because Missouri is an agency with the EEOC. They have a work sharing agreement, all right? So that really gets complicated. What I really want you to know for purposes in here is basically you have 180 days or 300 days, depending upon whether it's federal or state. Now, what happens when you file this charge? And it's the same, whether you file it with the EEOC or the state agency. Somebody investigates it. They look at it. Now, how do they investigate it? Generally, they send a letter, okay? So if Tom files a complaint against Lisa here, then, or against the company that Lisa works for, all right? Lisa's Tom's supervisor. Tom feels like he's being discriminated against, so he files a complaint against the employer. They go in, they'll send a letter to Lisa's company, and they'll say, hey, Lisa, we think your company, or you need to be aware. We don't think, we just want to let you know that your company has been accused of discrimination. And so we want to find out certain information, and we want you to cooperate. Now, you normally should cooperate. I'm just going to tell you now, if you're out there, you get one of these charges of discrimination, you're in the human practices or human resources or in management, and you get one of those, you generally want to cooperate. Because if you don't, they can subpoena you. And when they subpoena you, now you've ticked them off. So just cooperate with it. Every now and then there are times not to cooperate, but for the most part, you give them the information because they're going to get it one way or the other. So you cooperate with them, and then they look at it. Once they do their investigation, they may take statements, they may talk to people on the telephone. Once they do their investigation, there are basically three things that they can do. They'll either, and this is true federal or state, okay? They'll either issue what is called a probable cause statement or letter, probable cause letter. They'll issue what is called a no probable cause letter. Or they'll issue what is called a right to sue. Okay. So, go back over the three. Either they'll issue a probable cause, a no probable cause, or a right to sue. And a probable cause basically says, you know what, we've conducted our investigation, and based upon what you have said, we have found a violation, all right? So let's say that Tom files his charge of discrimination, and they go to Lisa and they say, Lisa, what do you think about this charge? And she goes, damn straight, he's a male and I can't stand him, okay? EEOC, Missouri Commission on Human Rights, they're going to go, yeah, there's a probable cause here that, that Lisa's discriminating against on the basis of sex. Okay. They can also issue what is called a no probable cause. And that's where the agency says, hey, we've looked at this, and we just don't think there's any way in the world that there can be a violation here. I'll give you an example, okay, an easy example. Person files a charge of discrimination with the Missouri Commission on Human Rights, and they have 5 employees, okay? Even if there's discrimination, there's going to be a no probable cause finding because what? They don't have enough employees, all right? So there's no violation because you don't have enough employees, all right? So with that in mind, there's going to be a no probable cause. Now, most of the time, what happens is you get what is called, this third thing, you get what is called a right to sue. Okay. Now, as an employer, when you get those right to sues, don't panic. It means nothing other than, you know what? It's a he said, she said. We can't make up our mind. We're not going to spend the resources on it. You want to go sue, you go sue. Okay? And while I was in private practice, when I would have people call me up, and because I generally represented employees, and I'd have employees call me up, and I was very picky on these cases. You can get 10 calls a day and take one a month, maybe. I mean, because everybody that's been fired thinks they have a cause of action, and sometimes they do, but majority they don't. But they would always tell me, "Oh, I've got a right to sue," you know. I've got a right to sue. That means the EEOC or the Missouri Commission on Human Rights thinks I have a great case. No, that just means they're not going to spend the resources on it to investigate it. They're going to let you go find an attorney that'll take it if you want to pursue it. Okay? So, no probable cause, right to sue. Whether it be in federal or state, again, Missouri, most states are similar. After you get that right to sue, you have 90 days to file your lawsuit. What happens if you don't file your lawsuit in 90 days? Kyle, let's just pick on you. Huh?
You lose your right.
You lose your right to sue. Yeah. So you file your lawsuit on 95th day, there's no lawsuit there. I mean, you may have to go through, remember way back to the very first day of class where we talked about motions to dismiss. That'll be on a motion to dismiss type of basis, okay? You file your lawsuit, the other side will say, hey, you didn't file it within 90 days, you're done. Court will say, yeah. Okay. The only other distinction that I want to give you on this, at the risk of confusing you even more with these time frames. Under federal law, if they don't give you your right to sue for 20 years, yeah, that raised some eyebrows and stuff, you still have your lawsuit, okay? Because as long as the EEOC is investigating it, then you can pursue with a lawsuit once you get your right to sue. Under Missouri, you have to file your lawsuit within 2 years from the date of the incident. Okay? So federal, you can go on forever. State, you can only go for 2 years. So, let's say that you file your charge of discrimination like you're supposed to. The Missouri Commission on Human Rights is investigating it. And 2 years goes by, and they have not issued you a right to sue. Can you, on one day before the 2-year period, file a lawsuit? I mean, you can always file a lawsuit. Let's put it that way. But it'll get dismissed because in order to file a lawsuit, you have to have what? You have to have a right to sue, all right? If Missouri doesn't give you that right to sue within 2 years, you're just SOL. Okay? And it doesn't happen very often, but it does happen. Okay? So, federal, they can go 20 years and then give you a right to sue, and you can sue within 90 days, because you got to sue within 90 days after your right to sue. Okay? But in state, you better be asking for your right to sue. And you have that right, by the way. You have the right to go and say, I want you to give me a right to sue. So that's kind of that procedure. Now, if they don't give you a right to sue, and you merely have a probable cause or a no probable cause, you have to appeal that. And that's a little harder, because in a right to sue, you're starting from scratch and you're going to the judge and you're saying, hey, you tell me what the results of this are and whether I win or whether I lose. All right? If you get a probable cause or a no probable cause, you basically are going to a judge and say, hey, this agency messed up in making their determination. Now you've got to show that the agency messed up. That's a harder burden than from starting from scratch. Okay? All right. Gets a little complicated with that, but any questions? Any questions with regard to those things? Yeah, Amanda.
Why wouldn't they be able to sue if there was probable cause? To me, that seems like it's more like you have a case.
Well, no, and that's a great question. That's a very good question. Generally, if you get a probable cause, let's deal with that. If you get a no probable cause, you're done. Okay, so you've got to appeal with that. If you get a probable cause, then you start into a whole new section of administrative procedures. For instance, the person who gets the probable cause is not going to appeal. All right? The employer may appeal that. But basically what happens is, let's say the Missouri Commission on Human Rights issues a probable cause. If they issue that probable cause, then they're going to either start mediation, or they're going to go through the procedure to see if the Missouri Commission on Human Rights wants to proceed or the EEOC wants to file the lawsuit. And if they don't, then you may get your right to sue. Okay? That's a good point. All right? Because if you get a probable cause, generally, it generally doesn't go a whole lot further than that, because a lot of times companies say, whoops, the agency has found we messed up. We're gonna deal. We're gonna settle. That's generally what happens. But you have absolutely the right to fight it or to mediate. Generally they'll say, let's mediate it. Do you want to mediate it? Sometimes you do, sometimes you don't. Okay? And then you can get your right to sue as the employee. Okay? All right, clear as mud on that stuff. I know that's a more boring, monotonous stuff, but procedurally it's important, and for practitioners it's important that you understand that. And a lot of this stuff, is law stuff, but you're the ones who are going to be practicing with it.
Can you think of an example where you would only want to sue with the state rather than the EEOC?
Great question. Great question. Yes. In fact, I will tell you, not always, but most attorneys in my position would say, or that do employment law, would say you probably commit malpractice if you go to federal court. Okay? So, with the exception, if somebody came to me too late to file a claim in state court, I'd end up in federal court. But frequently, I'd want to file in state court only. Here's the reason. Number one, anybody know the difference between most federal judges and state judges?
State judges are elected.
State judges are elected, and
Federal are appointed.
federal are appointed. All right, carry on with that. State judges have a job until when?
Re-election.
Re-election. All right, Missouri's a little bit different with some, and particularly here in Greene County, once our judges are appointed, they're appointed now, although that's on the ballot, by the way, to try to remove that here in statewide so that everybody's elected, but you can be retained, okay? But state judges elected until the next election, basically. Federal judges appointed for how long? What?
Life.
Yeah, almost life, okay? Now, why does that make a difference? Jackie, you're smiling.
Well, I mean, it seems cynical, but probably true that state judges are they'll be more willing to, you know, listen and try a case like this in a manner that's like a little bit more favorable to the person filing discrimination.
Absolutely. Absolutely. And you're right. It's cynical, and that's not to say, because I practiced in front of very good federal judges. I practiced in front of very good state judges, and they will do what is right. But here's the deal. A federal judge, if he gets it wrong, nobody's going to be really upset with him. He's still got a job, okay? If a state judge gets it wrong, he's got to deal with election issues. Federal judges are much more willing to throw out these discrimination cases on what we call summary judgment. Remember summary judgment, okay, from way back early on when we started several weeks ago? And this idea that after looking at all the facts, I will probably, when we get into the age discrimination, I'll probably show you an example of a summary judgment, okay, that we tried here. Well, I guess we didn't try it, got out on summary judgment, but show you an example. But federal courts are going to be more inclined, true in Missouri, true elsewhere, are going to be more inclined to grant summary judgment than state courts. In fact, I have had state judges tell me, Groves, you may be right, but first thing they tell us in judges school is never grant summary judgment. Okay? It's like, dang, they really tell you that? Yeah, they tell us that. Because then you're going to get reversed on appeal. And if you don't want to get reversed on appeal, don't grant summary judgment, because the judges won't, they'll say, yeah, there's a fact issue. All right? So, great question. But that's why, Patrick, you want to file in state court as opposed to federal court. And so frequently, even though you have a federal court claim, what I did when I was in private practice representing employees, if I felt it was right, felt I could do it time's sake and meet all the time requirements, simply file in state court and only file a charge of discrimination for the Missouri Commission on Human Rights Act, wouldn't mention the federal act. Now, if I file, let's say I file a charge of discrimination and file a lawsuit and mention both the EEOC or the federal laws, Title VII, and the state law, but I file it in state court, because I mention a federal law, the other side could remove it to federal court. Okay? You won't be tested on that, but just that's why you don't even want to mention the federal court claims. All right. Good questions. Any other questions? Yeah, Jack.
If the later amendments to Title VII are what gave it the ability to be prosecuted or taken to civil court, what was the point of the first, like what was the enforcement power of the first one? Was it a public policy
It's
thing?
really a public policy. You got to know, 64
Right.
is when it comes into it gave him some authority, but not much.
Okay.
It's a political. It really was all political. Okay. Now, that's how laws come out. You know, you start out with maybe a reason that's political, and then it gets some teeth to it. Okay. But no, good question. Okay. All right. Any other questions on kind of the history? Because where I'd like to go, and we may do that next week, is the types of discrimination.